on its face actually has a disproportionate negative effect on a protected group. Both forms are illegal, but disparate impact cases are significantly harder to prove without careful documentation and legal expertise. Sexual harassment is also covered under Title VII as a form of sex discrimination. There are two types courts recognize. Quid pro quo harassment, which is Latin for this for that, occurs when a supervisor conditions employment benefits on sexual favors. Hostile work environment harassment occurs when the conduct is so severe or pervasive that it creates an abusive working environment. A single comment rarely rises to that legal standard, but courts look at the totality of circumstances, frequency, severity, and whether the conduct is physically threatening or humiliating. But here is what nobody talks about when it comes to discrimination law: the retaliation protection may actually be more powerful in practice than the underlying discrimination claim itself. Federal law prohibits employers from taking adverse action against employees who report discrimination, file EOC charges, or participate in investigations. An adverse action can be termination, demotion, schedule changes, or even subtle moves like suddenly giving you negative performance reviews after years of positive ones. Retaliation claims now make up the largest single category of EOC charges. And courts have consistently found that retaliation cases are often easier to prove than the original discrimination claims because the employer's reaction creates a visible paper trail. This brings us to a critically important concept: the at-will employment doctrine. In 49 of 50 states, the default rule is that either the employer or the employee can end the employment relationship at any time, for any reason or no reason at all, without notice or liability. That sounds devastating for workers. And honestly, it is a significant power imbalance. But the exceptions to at-will employment are just as important as the rule itself. Employers cannot fire you for a discriminatory reason. They cannot